Good morning and welcome to Hope Hospice's Family Caregiver Education Series. I'm Debbie Emerson, Hope's community health educator and certified dementia specialist. My primary responsibility at Hope is developing and managing our Family Caregiver Education Series. And my goal is to bring presentations to you that contain really valuable information about all aspects of providing care for those we love. Today, we're fortunate to have as our guest speaker, Julie Fiedler, a local attorney who has been dedicated to protecting the rights of elders and families, seniors for over 35 years. Now, Julie has been gracious enough to present for us over the past several years, so I know you're going to be in good hands today. Okay, I'm often asked by caregivers if I can recommend an elder law attorney or an estate planner. So I just want to highlight 4 resources to help you in your search. And all of these websites are included on the resource list that accompanies the presentation. So you can always contact the National Association of Elder Law Attorneys. California Advocates for Nursing Home Reform, or CANNER, is one of my very favorite resources. They are very responsive to emails and phone calls, usually within 24 hours or less has been my experience. Now, their title is a little bit deceptive because they do so much more than just advocating for persons residing in nursing homes. And they have lots and lots of information on their website about Medi-Cal, VA, elder abuse, and lots more. The Family Caregiver Alliance is another one of my trusted go-to online resources. Again, lots of great info about many of today's topics. And then, of course, Julie Fiedler is my go-to referral for elder law issues in the Tri-Valley area. All right, with that being said, it's now my pleasure to formally introduce you to our guest presenter and share just a few items from her resume. So Julie is a certified elder law attorney, and she's also a registered nurse. And she has over, as I said in the beginning, she has over 35 years of experience in healthcare and senior services. She served 2 terms on the board of directors for the National Academy of Elder Law Attorneys and is the past president for the Northern California chapter of the National Academy of Elder Law Attorneys. She's accredited by the Department of Veterans Affairs to help individuals in all matters involving VA benefits. And if you've ever tried to navigate veterans benefits on your own, you know how difficult and frustrating that can be. And when I did this for my mom several years ago, I sure wish I'd had someone to help me who knew the system and who could advocate on our behalf. And Julie is also an active member of CANNER. I mentioned that earlier. Julie, thank you so much for presenting to our group today. And if you have any additions or corrections to information that's up on the screen, please just let us know. As I mentioned, Julie will not be using slides today. So if you do have her presentation summary that I made available to you, please follow along with that. All right, I'm going to stop my screen share now, and then I'm going to turn everything over to Julie.
So I want to start with talking about just the basics of the whole legal system. And when you're dealing with these kinds of issues of aging and loss of capacity and care issues, our general guiding principle is we want to keep people as independent as possible and in control over their own lives as much as possible. So the law reflects that in that people can't just start making decisions for you without your consent. They can't just put you into a home if you don't want to go. I mean, these are just civil rights that we have. So the first part of the presentation is just pretty much saying, when we're dealing with issues of aging and capacity, we always start with assuming the person has the ability to make decisions to handle their actions. And then we just kind of go slowly as to giving more assistance, from starting with having legal documents that allow a family member or a friend to make decisions for you, sign your name for things, whether it's financial documents, consents, things like that, all the way up to fully making decisions, as to where you live and the care you receive and that sort of thing. So I want to go kind of a general overview of estate planning, because the documents that we create in estate planning are for this goal of keeping people in control, or if they're not able to be in control themselves, they've set up something where their wishes are known and they have a person who has the legal authority to enact those wishes. So just kind of a brief overview of the various documents in an estate plan, and many of you may be familiar with these. We generally are looking at a will and or a trust. A lot of people don't know the difference between a will and a trust. So let me kind of quickly go over that. A will basically does not come into being or be an active document until you die. So if you put language in your will that says, hey, if I need to go to a nursing home, you have my permission, or I don't want to go, that will doesn't have any control. It kicks in when you die. And basically the purpose of a will is to say who's going to manage my estate and where does my estate go. A will does not necessarily avoid probate. Probate is the court process we have of passing property from a deceased person to whoever the property is supposed to go to. So generally, if you have a will, the court will what they call probate the will. In other words, they'll enforce the will, but it does go through the court process. And that's something we'll talk about. Everyone in California wants to avoid probate because probate is expensive. It takes a long time. Sometimes it becomes contested. It's totally a public proceeding. So anybody is aware of everything going on in your family, which for the most part, nobody does anything nefarious, but you do get a lot of people that market based on probates. So as soon as you file a probate, you're going to get a lot of phone calls from realtors, from financial people, from insurance salesmen, all kinds of people that they scour the probate records, and when a name pops up, they think, future client. So, we all like to keep our affairs quiet. We don't really want to be hounded. So avoiding probate is really important. So in California, if you have more than, and each year it changes, but this year it's about $185,000 that is not titled with a beneficiary designated. Like generally on your IRA, your retirement plan, you will have named a beneficiary. Life insurance, you generally name a beneficiary. Even on bank accounts, you can have a transfer on death or pay on death designation. None of those things are going to be subject to probate because they already have a designation of where they're supposed to go. So those things happen automatically. The other time is if you hold joint ownership with someone. So for example, a couple owns a bank account together. If one of them dies, it stays with the other one. There's no probate involved. But if you have any assets that don't have beneficiary designations, what they look at is the total of all those assets valued at 185,000. If it is, then your executor needs to file a probate in order to access all of the assets and ultimately distribute them. So one of the ways that we avoid probate is to create a trust. And a trust sort of acts like a will. It does say within the trust what happens when you die. And it also says who's going to be the person to manage the estate. But the difference is that a trust is a legal entity that actually owns property. So whereas I'm an individual, I own property in my own name, whether it's a bank account or it's my house, has my name on it, I own it. When I die, then we have this asset that's in the name of a dead person, for lack of a better term. And so somebody has to do something to transfer that asset to a living person. When you create a trust and you transfer your assets, so you at the bank, you just change the name on the bank account. With your real estate, you do a deed to the trust so that things are titled in the trust. So what happens then is now you are the trustee of the trust or the manager of it. So you're still managing your property, but the trust being a non-living being, it it doesn't die. So if you die, the trust is set up that someone else just steps right in and does whatever the trust says is supposed to happen. And this is why we don't need the probate court to jump in, because we don't have ownership just out there without somebody attached to it. So again, when you create a trust, it's really important that you title property in it. And I do have a lot of people that come to me, created a trust years ago. And as we discuss it and we talk about their assets, come to find out nothing is titled in the trust. Well, a trust is only as good as what it owns. Just like I can't deal with property that's not in my name. The trust can't deal with property that's not in the trust name. So if you do have a trust, really important to check your assets, make sure that you did title things in the trust. One thing we do recommend is when you create a trust, generally we leave your checking account out, primarily because checking accounts have a lot of automatic deposits, automatic withdrawals, your social security, your pension, your, employment, is automatically deposited. When you transfer an account to a trust, the bank usually changes the account number, in which case all of that automatic stuff is going to go haywire. So you'll have to reestablish those things, and it's really not worth the effort. So we generally say, put your savings accounts, investment accounts, real estate, stocks and bonds, any other properties you want to title in the trust. Checking account, we generally say, put a pay on death designation on the account to the trust. And that way, if you die, it goes to the trust. Excuse me. But it doesn't change the account while you're alive, which will mess with those automatic deposits and withdrawals. So that's kind of the difference between the will and the trust. And that is primarily for the purpose of transferring property when you die. The other thing with a trust is we can put a lot of flexible language so you can kind of control beyond just saying all of my stuff goes to my kids. What if one of my children is disabled and is getting government benefits? In the trust, we can put language that the money that they inherit is protected, so they won't lose their government benefits, but the inheritance will be there to supplement that. So, or say you have a spendthrift child that, if they inherit $50,000, it's going to be gone tomorrow. You can put language in there that holds it in trust and distributes it over time or based on someone's discretion. So there's a lot of flexibility in what happens after you die that you can put in the trust, which generally makes people feel better that here, I've worked so hard all my life for what I've got. I want to make sure it goes to the people I want and for the purposes I want. And certainly charities are another thing you can always leave to charity. I have a lot of clients that do that, just a portion or all, whatever. So basically that's the will and the trust. Primarily, they do hold property, or the trust does, during life. But as I said before, you're managing it. It's still under your social security number. So for all intents and purposes, doesn't really affect you during life. It really, the major mechanisms kick in if you become incapacitated or you die. That being said, in managing just your general finances, whether it's paying your bills, accessing the checking account that maybe we left out of the trust, even things like dealing with your PG&E bill, your utilities. It wasn't until the last few years I've had people call up and say, I tried calling PG&E and they won't talk to me because it's in my father's name and I'm not my father and I can't get him on the phone because he's had whatever incident and can't talk. And it's like, wow, okay, that's a problem, because certainly you may need to do something regarding those utilities or any other account that a person has. And that's where the power of attorney comes in. So you execute a durable power of attorney that names who can be in charge, who has the ability to talk to people, as well as signing documents, paying bills, taking care of stuff. And then the document also tells what authority they do have. So presumably you want them to have the maximum amount of authority so that they can take care of whatever's going on. But some people maybe have some restrictions that they don't want them to handle certain things. So all of that is written into the power of attorney. It's really important that everyone has a power of attorney from the time you're 18. And I do get some clients that have kids that have turned 18, going off to college. Well, if anything happens to that kid while they're off at college, you no longer have any control. They are an adult now, and things really change. So from the time someone's 18, and I mention this, maybe it's not something you're dealing with, but maybe your kids or your grandkids might be. So just to be aware of, at all ages, a power of attorney, everyone should have it just in case. And I think the COVID pandemic really opened our eyes to that, that anything can happen at any time. We just never know. People get sick, people have accidents. That way, if something happens, you're prepared. Your life doesn't just stop because unfortunately, bills don't stop, things don't stop. So, without a power of attorney, if someone wants to help you, generally they're going to have to go to court to get what's called a conservatorship in order to get that legal authority. And I'll talk a little bit more about that later. But that's the power of attorney. The other document that's really, really important during life, and I know Debbie has had presentations on this before, is the Advanced Healthcare Directive. And I think most people are pretty aware of the need for those, but there's always people that procrastinate and say, oh, yeah, I'll do that one of these days. If you don't have one, you really should. It does the same thing as the power of attorney, except that it appoints someone to make medical decisions and care decisions and to have the ability to actually have a conversation with the doctor about private information so that they can make those decisions. So the healthcare directive and the power of attorney are the two documents that I recommend. Make sure you have them, make sure they're up to date.
Julie, excuse me a sec.
Yes.
Sorry, I have a question that
Okay.
has come up many times, and that is there a difference between an advanced healthcare directive and a medical power of attorney?
Basically, the Advanced Healthcare Directive appoints a person to make those decisions, and it also tells what kinds of decisions they want made. Generally, an Advanced Healthcare Directive does not get into the nitty gritty of every decision because we honestly don't know what decisions are gonna be needed, what our condition's gonna be. So it's kind of a broad view of, end of life. What are my thoughts on being kept alive on life support? When I die, do I want to be cremated or buried? Things like that, but not into the nitty gritty of care decisions. But this is the legal document that puts somebody in charge. Now, there was a prior law where we called it a power of attorney for healthcare. And those were done primarily in the 90s, some from the early 2000s. The law changed, and I honestly don't remember when, but it's somewhere around 2000 where we came up with the Advanced Healthcare Directive, where they changed the name because a lot of times people would confuse the durable power of attorney for finances and the power of attorney for healthcare. And they might have one, but not the other, not realize it. So that's why they changed the name to be Advanced Healthcare Directive. Very clear what we're talking about. But there are a lot of those old durable power of attorney for healthcare directives out there. They are valid, but I generally recommend, because they're generally old and they usually don't have language in them that is compliant with the HIPAA laws, the privacy laws. So it's not a bad idea to update those if that's what you've got. If that's all you've got and you're not able to update it, generally they will be honored by healthcare providers. And they pretty much serve the same purpose. It's just that back then, like I say, they weren't as specific to healthcare. And although the document was, but people didn't realize that. So people were trying to use them for financial documents. And again, they don't get into the nitty gritty of actual decisions. And that's where the pulse comes in. So I want to kind of talk about that too. The POLST document, it's a physician's order for life-sustaining treatment. So it's actually a doctor's order, and it comes, and it used to be on a bright magenta, purple colored paper. I'm not sure if they still do that, but it gets into more of the nitty-gritty of the actual medical things that you've decided you either want or don't want after a discussion with your doctor. And you sign it and your doctor signs it. And it gets into things like, do you want dialysis if your kidneys aren't working? Do you want to be put on a ventilator if you're not breathing well? Do you want tube feedings if you're not able to eat? Things like that, very specific medical treatments, and that stays with your medical record. And that goes with you for your life. Generally, what I'm hearing from most clients is if they ever go in the emergency room, they always want them to sign a new one, which kind of defeats the purpose of doing it while you're healthy and able to make that decision, because now you're in a crisis and you may not make the best decision. That being said, it goes back to giving people the opportunity to have as much control as possible. And sometimes what you may have decided in a calm moment when something wasn't really an issue may be different than what you're willing to do when you're in a crisis situation. So I do see that you may change your mind, because when you're young and healthy, it's like, and I remember my son saying this, if I ever get cancer, pull the plug. Well, okay, that's nice. You're young and healthy. If you ever did get cancer, you can still have a meaningful life. Maybe we don't want to pull the plug immediately. So you may change your mind as time goes by and as your situation changes. What you're willing to live with might be different now than it was years ago. So those documents working together, like I say, the kind of outdated power of attorney for healthcare is still okay, but generally we recommend the Advanced Healthcare Directive. And then the POLST document, generally I don't recommend that until you are getting older, or if you have any major diagnoses that are going to lead to this kind of pretty invasive treatments and you want to have your wishes known. I have heard some people doing talks that say, oh yeah, everybody should have a pulse. Not necessarily. I think if you're 30 years old, it's really hard to make that decision. And you sure don't want to get in a car accident, go in the hospital, and they say, well, they said they didn't want anything. Well, let them die, when they could have treated you and saved your life, and you could have gone on to have a full life. So generally, it's something that we don't generally do till we're older or have some sort of diagnosis. And again, that document is obtained through your doctor or nurse practitioner, where you actually discuss those treatments and what your wishes are. So that's as far as making healthcare decisions. And I know, Debbie, you probably have another whole webinar on the healthcare decisions and the 5 wishes, which is a valid advanced healthcare document, which really gives a little bit more as far as what your wishes are than what a standard attorney drafted one tells about. So I won't get any farther. And plus, we have a lot of other things to talk about. So those are the primary things that you put in place. You get your will, you get your trust, you make sure everything's titled properly, you have beneficiaries designated on your retirement accounts, your life insurance, that sort of thing. And you have those powers of attorney and advanced healthcare directives. And then you're good to go with your life. You just move on with your life. These aren't things that you have to stress about. You don't have to do anything on a regular basis. You just take care of your life. But if something happens to you, everything is set up that the process will very easily transfer to the person that's going to help you out. And that way they're not, in a bind with, I can't talk to people, the bank won't let me pay the mortgage, whatever it is, because I do get a lot of calls from that. Well, the bank says that we can't do anything. Well, yeah, because you don't really have any authority. Bank's not just going to let anybody come along and say, oh, my father had a stroke, so here I am to write checks on his account. They do have protections there. So this is where all of those documents are going to help someone, whether it's you for someone else or someone else for you, take over at the point when you're not able to. The other thing is that sometimes it's not even that we're not able to, but we may not want to. You get to a certain age, it's like, you know what, my kids are handling my finances. Give them that power of attorney. I trust them totally. Let them manage those finances. We do recommend when you're involving others that you don't put them on title on your account as a co-owner, but rather you give the bank that power of attorney that gives them full access, but not ownership to your assets. The primary problems with putting them on title is if something happens to them and their name is on title, your money could be at risk because they're an owner of your property now. So, for example, they cause a car accident and get sued, that lawsuit's going to go after anything that their name is on. There's a judgment against them. They can come after your money. The other thing is if you die because they're a co-owner on that account, they just take the account, which in some cases, if it's an only child and that's where it's going to go anyway, that's one situation. What I find is there'll be 4 or 5 kids. One kid was helping mom, got on all the accounts, and when mom died, everything went to that child because they're on the account. Some kids will do the honorable thing and share it with their siblings. Some not so much. They feel like, I've been helping mom, nobody else stepped in, I deserve it, and then there are also gifting issues that if mom leaves something as an inheritance, that's treated differently from a tax perspective than if everything went to that surviving child on the account and they gifted that money to their siblings. There's different requirements of notifying the IRS and potentially tax issues. Generally not serious ones, but something that does need to be looked at. And we're not going to get into the deep tax stuff, but suffice it to say, we don't recommend having someone on your account unless, like I say, it's an only child, not a big, huge account. And that's something I would discuss with your attorney as to whether or not it's a good idea in your circumstance. So I do want to move on to, when you have, what I was talking about before is primarily when you just own your own property and you're transferring it or you die and it's going to people. The other thing is if you have co-ownership with someone else, oftentimes with spouses, you're both on title on everything. As I said, ultimately, we do want to try and have things titled in a trust, but in a lot of cases, prior to getting a trust or for whatever reason, you may have joint ownership in different manners. So one way that people sometimes will hold title is joint tenancy. And I want to give you the differences between that and tenants in common, because most people don't know. I remember when I purchased my first house, they asked my husband and me, how do you want to hold title, as joint tenants or tenants in common? And my response, granted I was very young, was, I don't know, but I heard there's a good way to do it. I want to do it the good way. What does that mean? That was my ignorance, but I'm telling you, if you don't know, you don't know. So joint tenancy is where you take title together, and if any one of those joint tenants, and it can be 2, 3, 4, however many, if anyone dies, it automatically goes to the surviving joint tenants, just automatic. So if there's 2 of you, your 50% goes to the survivor. If there's 3 of you, your third goes to the 2 survivors, and now they're 50-50 owners, and on up, depending on how many people. It's divided evenly between the other owners. The issue with that is if you're doing that, and oftentimes I've seen siblings do this, they inherit a house from mom and dad, they just take title as joint tenants. And the way I like to say it is, well, whoever dies last wins, because everybody else, when they died, went to those surviving siblings. The last sibling to die can then leave it to their kids or whoever they want. So that may or may not be a good way to hold title. Just really depends on what your goals are. The other way is tenants in common, and that's where you actually have individual ownership of your share. So let's say there's two of you as tenants in common. Generally, we don't see that with married couples, but we see it more with siblings or just, friends that own property together, where each one of you, let's say there's two of you as tenants in common. On my share is going to go based on my estate plan when I die. It's not automatically going to go to that other person. Their share will go based on their estate plan. So if either one of us dies, we still have control over where our share goes. The issue with that is you better have an estate plan or it may end up going through probate. Now you've got potentially a house where the survivor's on title, but the other half is in probate. Well, what if that survivor needs to sell the house or finance the house? It's stuck in probate. So if you ever hold title as tenants in common, really important that you have your estate plan put together. And generally what I say is you have your trust as the owner of the tenant in common interest that you have. And that way your trust will direct your share at whatever time something happens to you. So if there's two of you, basically there's two trusts owning it. One trust is one tenant in common, the other trust is the other tenant in common. So it's different than the joint tenancy where it just automatically goes back and forth. The other thing, again, pay on death designations on things. There is in California fairly new law that you can do a revocable transfer on death deed on your real estate. To be honest, I don't recommend it. What I have heard is a lot of title companies are not wanting to insure title. And if you can't get title insurance, it's really difficult to sell a house. And the main reason for that is because it's a revocable document, the title insurance company doesn't know if at some point during your life you revoked it and it's just didn't get to the county recorder's office yet, because a revocation is valid at the time you sign it. So there may be a revocation out there, and now that transfer deed is no longer valid, but the title company will pull title from the county assessor or the county recorder, and they're not going to know it's whether or not it's still in place. So they're going to say, well, if you transfer it to this beneficiary, somebody else may come along and pull out this revocation and say wasn't supposed to go to them. So it's kind of a dangerous way of doing it. That being said, again, in a very simple situation where it's you and your child and there's nobody else involved, sometimes it's fine. Again, I would just always recommend you get legal advice before you do something with real estate like that, especially with the value of what real estate is these days. You really don't want to make a mistake on that. Then the other thing is, I'm just kind of going through my outline. So if you have it, you can kind of see. Community property is if you're married. Basically, California is a community property state. So essentially anything that you earn together, put in your joint accounts, that's community property. And that is separate from your separate property. Separate property is anything that you either inherited or someone gave you separate from your spouse, and you didn't commingle it with all the assets that you hold jointly. So let's say you inherit a portion of a house, you don't put your spouse's name on it, you keep it separate, that remains your separate property. Or you leave it in a bank account that doesn't have your spouse's name on it, that stays your separate property. The other thing is property that you had prior to marriage. So again, that's a whole almost family law as well as estate planning issue, that usually doesn't come up except for in divorce. Who gets what? Separate property goes to the separate person, community property gets distributed equally, but sometimes communities are gaining an interest in the separate property. That's a whole other area. We're generally talking about what happens when we die, and generally in your estate plan, you're going to identify, let's say, you've got his and her kids. Well, my separate property that I inherited from my parent, I want it to go to my kids. Whereas the stuff we had together, let's have equal between all the kids, things like that. So that's kind of the implications of community versus separate property. Certainly, the other thing is As far as managing money, one of the things on here we're talking about is direct deposit and representative payee. When you're getting Social Security benefits and veterans benefits, and usually pensions, they will have you automatically set up a direct deposit. So every month it just goes automatically into your account. Um, that just simplifies everything. Where a representative payee comes in is if you are incapacitated and you're not able to manage those Social Security benefits or veterans benefits. That's where, and again, we're looking at somebody needs to take charge. If you already have it going as direct deposit into your account, unless something changes with Social Security, that'll keep going. So you don't necessarily need a rep payee if you've got that set up properly. But if something happened to that account got closed, unless you're able to direct Social Security as to a new account, nobody else is going to be able to. And if you have maybe lost capacity, that's where your agent will need to apply to Social Security to be your representative payee. And then Social Security will distribute the checks to that person, who will then have to do an annual accounting to the Social Security Administration as to what they did with your money, but they then will be managing it for you. So that's the way we help with the Social Security benefits. The VA has a similar process of appointing a representative to manage your veterans benefits, and any benefits that anyone's managing from the government for you, they will have to do an accounting to the government as to what they did to hopefully keep them honest, and hopefully your family members will be honest. But that's the protections that are in place. We talked about the trust. If something happens, and I mentioned this before, where you don't have those proper documents of a power of attorney, healthcare directive, and even a trust, and something happens to you and nobody has that legal authority to step in, that's where we end up petitioning the court to get a conservatorship. And basically what happens is someone will file a petition with the court. Everybody in the family will get notice that you filed this petition. Hopefully nobody will object. If they do, then you've got that whole battle. But as long as everybody is in agreement, you'll have doctor's evidence showing that you're not able to manage your affairs or make decisions or whatever. And then the judge will appoint that person as your conservator, which basically gives them the same powers that they would have had you signed that power of attorney or created a trust and put them on as the successor trustee. The difference is that now you're subject to court supervision. So for the rest of your life, the court is going to require an accounting, and it's a lot more cumbersome than the Social Security or the VA accountings, which are generally a one-page, easy, one and done thing. The court conservatorships generally in attorney's fees alone cost somewhere around $5,000 every other year to do those accountings, because they have to be done in a very specific format, kind of complicated. You have to have a court hearing. It's definitely an expensive way to go. And as I said, you really lose control over your own stuff when the court is telling them what they can and cannot do. So just as we want to avoid probate after you die, we really want to avoid conservatorships while you're alive just because of this. But there are times when it's inevitable. We didn't get our documents done, or maybe we did documents and the people we appointed have all died. I've seen that happen. So it's like we had it together, but we didn't keep it updated. Things happen. And in that case, if you have a situation where you're trying to help someone else out, you don't have access to their assets, definitely talk to an estate planning attorney or an elder law attorney to find out what are your options for accessing that money, taking care of your loved ones. Sometimes it is a conservatorship. Sometimes there are things we can do short of a conservatorship. But you definitely want to get legal advice as to what you need to do. And just because I just mentioned that, I do want to throw out there, because I always forget to talk about this, but I think it's important. There is a difference between an estate planning attorney and an elder law attorney. And a lot of people don't even realize what that is. A lot of people think elder law attorneys deal with elder abuse, which some do. But that is a completely separate area that there are specialists that do that. Personally, I don't do that. I do more of the planning, the healthcare issues, that sort of thing. When I get people stealing and scamming and harming people, I will refer it to a litigator, someone that specializes in elder abuse cases. Very different animal there when you're dealing with that kind of thing. You know, there's criminal laws, there's civil laws. So that's a separate kind. But in your basic elder law attorney, like I am, and an estate planning attorney, historically, estate planning attorneys look at death and taxes. We want to avoid probate. I've already talked about that. We want to minimize taxes. Absolutely. So in the documents that they prepare, these are their primary goals. What I have discovered over the years, and not just me, but we are all living a lot longer. And we're having a lot more issues than we ever used to have when we died earlier. Granted, dying early is not a good thing, but it did solve some problems of some of these. How do we deal with an incapacitated person over the years? You know, how do we figure out how we pay to take care of that person over the years? So things have changed. An elder law attorney really focuses not just on the death aspects, but on those living aspects. What happens if I live to be 100 years old? And how are we going to cover the cost of that? We generally, you know, historically, we retired at age 65, which most people aren't doing as much now. People are definitely working later. But back when Social Security was first created, it was created that you retire at 65 and you die before you're 70. And the government pretty much takes care of you with Medicare for your medical insurance, Social Security for your income, and you were pretty much taken care of in your old age. We don't die before 70 generally anymore. Now some people do, but as a society, our life expectancy has increased a lot. So at this point, Social Security is not really going to be enough income to sustain you for the rest of your life if you have care issues and you got to pay for that care. Social Security is helpful, but it's generally not enough for a long life. People don't get pensions the way they used to. That used to be a big source of retirement. A lot of companies are giving you, retirement funds, but it's a limited benefit. It doesn't go on for the rest of your life. It goes on for however long your retirement account lasts. So that's where elder law attorneys are different. We're creating documents and we're working with your current financial advisors and you to figure out, what do you have? What's the potential for your life expectancy? So we're often looking at family. Do your family tend to die young from heart attacks? Or does dementia run in your family? Because a lot of things, are genetic. So again, statistic, we don't know that that's necessarily going to be your fate, but we're looking at that to say, and I get people to come in and say, oh yeah, all of my family members lived till they were 100. So good chance you will too. So we want to see, how do we plan your estate so that your finances will last that long, whether you're planning with just the way you invest your assets with your financial advisor, basic insurances, whether it's life insurance with maybe long-term care insurance riders or straight long-term care insurance, really important to look at. And there are less and less companies that are selling straight long-term care insurance. For a while there, it was the big thing. A lot of insurance companies got into it. And then when people started making claims, they all went belly up because they couldn't afford the claims. So it's getting a little bit harder to get, but I do recommend some sort of long-term care insurance. And if you don't necessarily have it and you don't know whether you want it, better to investigate it than to leave it on the table and not at least look to see if it's an option, because there are all sorts of plans that go from really basic that can really help tide you over to what I call the Cadillac plans. because I deal with this and I have for so many years. I got long-term care insurance when I was 40 years old. I hardly pay anything for it because I was so young. It does go up, periodically, but it covers everything. My kids don't have to worry about paying for any of my long-term care because I've got it covered. That's partly because I got it when I was so young. Most people are older when they get it. Premiums are a little bit higher. But again, you can customize that insurance so that you get an amount that you can afford the premiums, but will definitely help stretch out those dollars. Then there's also things like planning for veterans benefits if you're a veteran or you're a surviving spouse of a veteran, Medi-Cal benefits for, when you need certain types of care, like in a skilled nursing facility. And we're going to get into some of that next, but I think we'll take a break before we do that. But again, that's just what the elder law attorney does. So an estate planning attorney, great resources. They're great people. They do good work. But as you get older, it's often a good idea to start talking to an elder law attorney. I had somebody explain it one time that you may have this wonderful speedy little sports car all your life, and then you go and you move to a big farm. Well, your speedy little sports car isn't going to help you on the farm. Might be time to get a pickup truck. It's the same kind of thing. There's nothing wrong with that sports car, but it may not be serving the purpose that you have at that time when you really need a truck. So it's the same kind of thing with elder law and estate planning. So just wanted to throw that out there. Probably told you more than I needed to, but that's what I sometimes do. Let me see yeah, we kind of talked about the healthcare's conservatorship, the LPS conservatorship. Just mentioned that it is in the materials. That is something that the government brings, generally for mental health conditions. So that's not something the general public would be involved with at all. That's generally Adult Protective Services gets involved, Public Guardian gets involved, and it is a law. It's the Lanterman Petrus, I actually said it right, act that just was put in place to protect those people that have mental illness. They don't have dementia, but they definitely need some protections where the government steps in to protect them. So that's what that's all about.
One of the things I wanted to mention to you, because Julie was talking before the break about long-term care insurance. And sometimes, you wonder, if I'm over a certain age, is it going to be worth it? Are the premiums going to be, way too high for me? And one of the best ways to explore that is to use this really wonderful free government agency, and it's called HICAP, HICAP. It stands for Health Insurance Counseling and Advocacy Program. On the resource list that that accompanies the presentation, I have the websites for Alameda County, Contra Costa County, and then I also have a link if you're in a county other than those two to find out what the version of a HICAP, and they call it, there's different names for them. But anyway, in Alameda County, we call it HICAP or Lash HICAP. And anyway, you can call one of their counselors and you can tell them, what your specific circumstances are, what your needs are, and they can counsel you on what might be the best thing to do for long-term care insurance.
I just want to piggyback onto that. HICAP counselors are also Medicare counselors. And my experience with them is they know everything Medicare. They are so helpful answering all the questions, because whether you're just starting out trying to figure out the system or you're somewhere deep into it and things are coming up and right now it's the enrollment period, maybe it's time to change. So if you have any questions, Medicare, HICAP is a great resource. And as Debbie said, it is free. It's a government funded program. So, but they'll give you some really good, helpful advice and resources. So
HICAP is actually doing our webinar in November.
That's great.
And it's one of their directors that's doing it. So she's amazing and, incredibly knowledgeable. So, call them up,
Yeah.
request a personal appointment. There's a request form online, or you can just call them up. But yeah, they're pretty amazing.
Yeah.
Okay, Julie, back to you.
Yeah. I may want to attend that webinar myself because Medicare is so confusing. And I get a lot of people asking me, and honestly, I tell them call HiCap. So, because that's my go-to. But I would like to hear her talk about, just the broad, what's going on in the Medicare world. So I definitely encourage all of you to attend that program because I mean, most people are dealing with Medicare in one aspect or another once you're over 65. So get your questions answered, get some information. I think that's going to be a really good program. So back to where I left off, want to talk about, I think on the outline, it talks about public benefits, government benefits, that sort of thing. I want to start off with kind of talking about the it's not a timeline of care, but it's kind of the continuum of care where, when you start off, you are totally healthy, you take care of yourself, you're independent, everything's fine. You start having some medical issues or some cognitive issues. And generally, the first thing that people do is they'll hire someone to come into the home to help them out, and it may be once a week, twice a week, maybe starting off with just helping with the errands, running to the store, vacuuming the floors. But, as time goes on, depending again on the health issues, you may need more and more assistance. And you can increase those hours, get the kind of help that is based on whatever your needs are. Generally, the kind of home care most people are getting is not medical care, not nursing care, but more of just general assistance. So help with preparing meals, cleaning up, just keeping you company, getting your grocery shopping done, things like that. There are just a few companies that offer home health care. So if you need things like assistance with your diabetes and blood sugar checks, insulin, things like that, that's generally ordered through a medical provider. And usually that kind of home health care is covered at least in part by Medicare or other private insurances because it's more of a health thing rather than just assistance. General assistance in home is basically privately funded. So the one thing with that, like I say, you generally start off with not too many days, not too many hours, fairly reasonable. Although in the Bay Area, the average cost for a home caregiver is somewhere, I used to say 25, but I have a feeling that's kind of gone out the window with inflation, but more like probably $30 to $35 an hour. And a lot of them have a 4-hour minimum. So you are spending couple $100 each day that they come. But if you need that help over, if they only come in once or twice a week, it's doable. I mean, nobody likes to spend that money, but that keeps you at home, keeps you independent, just with that little bit of assistance. The one program that does assist with that kind of care is generally when your care needs get to be a lot more. So when you're starting to have people need to come in daily or almost daily, long hours during the day, you're really needing help with more physical stuff like bathing, getting dressed, preparing food, potentially chopping it up, that sort of thing, to eat. More physical care in addition to care of the home around you. As you increase hours, it gets more and more expensive, obviously. So there is a Medi-Cal program, which is not really available to a lot of people, but it is available to some. So I want to mention it. You do have to qualify for Medi-Cal, which I'll get into a little bit later, but once you're on Medi-Cal, it's called in-home support service. And basically it's where Medi-Cal pays a caregiver to provide those services for you. Now, there is a limited number of hours that they'll approve. And the way it works is you apply for the program, they'll send a social worker to your house to assess what your needs are. And then from that assessment, they'll determine how many hours you're approved for. And then the worker comes in, they punch a time clock to do those hours, and Medi-Cal pays them basically their paycheck. Generally, depending on the number of hours you really need, Medi-Cal's not going to cover 24-hour care. They're going to cover a lot less than that. And a lot of caregivers aren't going to want to accept what Medi-Cal's paying, which I looked it up recently, and I can't remember if it's somewhere around $10 or $12 an hour, which again, these days is not a lot. Maybe going up with inflation and cost of living increases, but it's generally less than a caregiver can make out on the open market if they worked for an agency or something. So sometimes it's hard to find caregivers. We have had some people be creative with those caregivers where the Medi-Cal in-home support service pays them for X number of hours, and then the client will hire them for a few extra hours at a really high rate, which kind of compensates for all those short hours. So Medi-Cal is really assisting, but you still are putting some out of your pocket, but that kind of opens up more caregivers that are willing to do it because they're making more money. So they're making their money from in-home support service, but on the side, their side job is working for you at a higher rate. So that's one thing, that a creative way of doing it that I've had people do. Now, that being said, like I say, Medi-Cal, you've got to qualify for that. It is also an income-based program. So Medi-Cal is going to assign that your income pays for the first hours until whatever the income level that they have assigned is all used up. And from that point, Medi-Cal pays the remainder of hours. So potentially, Medi-Cal could say, you're approved for 100 hours, and here's your share of cost, which is essentially 100 hours worth of $10 an hour, whatever that. I'm not good with math on the fly. But essentially, you're going to be paying for those hours, and then you finished paying, but your 100 hours are now used up because they're counted within the hours you're paying. And this is where it's not a great program for a lot of people. If your income is high and you don't get a ton of hours, you're generally paying for them anyway. So the program doesn't really help you a whole lot. So definitely a program to look into, especially if you're low income. But again, it's sort of a restricted program that doesn't help everybody. But for those that can qualify, I have one recently where the husband actually had to quit working, making his salary to take care of his wife. And they were able to get in-home support service, and he became the worker. And now he's getting paid. And what he ended up telling us was he's getting paid more than he did in his other job because he's working kind of full time, taking care of his wife. But he's also got medical insurance through the Medi-Cal program as a worker. So sometimes it works with families to be the caregivers too, in addition to, just professional caregivers. So that's the in-home support service program. But other than that, veterans, and again, I'll get into that a little bit more, veterans can pay a little bit towards home care too, but let me put that off till just a little bit later. So once you get to a certain point of home care where it really gets too expensive because you need so many hours, this is where we're often looking at placement in some kind of a care facility. And, short of that, obviously you can utilize family members, friends to help out, but once you get to a certain point, you've exhausted all of those other resources, you're really spending too much, because home care can cost somewhere upwards of $10,000 to $20,000 a month if you need it around the clock. Most people can't afford that on a long-term basis. So that's where we're looking at a facility. The types of facilities that most people are going to, and I just kind of want to explain the difference. Assisted living facilities are generally where you have your own small apartment in a larger congregate living place where they have community meals, they have activities, There are caregivers that will come in. They have housekeeping services that come in. You generally will pay a base amount, and then depending on care assistance that you need. So if you need assistance with your medications, there'll be an additional charge. If you need assistance with bathing, you'll need another, there'll be another charge. So they add to that base rate. But that's assisted living. There's a lot of places out there. And Medi-Cal, unfortunately, does not cover assisted livings. There is a Medi-Cal waiver program for assisted living that that can cover certain facilities. This is a program that started in Southern California, was a very successful program, saved the state a lot of money, so therefore the state has expanded it to Northern California. But what I'm finding, especially in the Bay Area, is a lot of the assisted living facilities and boarding cares, which I'm going to get into, are not willing to get licensed under that program because Medi-Cal generally pays less than private people pay. And Medi-Cal has a lot of very strict criteria as to the quality of the home, the layout of the home, or the facility, how many bathrooms there are. And, there's just government regulations, which it makes sense. They're trying to protect the public. But because of that, a lot of facilities say, no, I'm just going to have private people. So there's not a lot of those types of facilities. And the ones we do have often have a long waiting list. Honestly, I've been doing this for years and years. I have never had one get approved for one of those. And I've been doing this a long time. I'm not saying that people don't, but it is definitely not a really useful program. So primarily you're on your own with assisted living. The other type of facility that we're looking at is board and care. And that's basically where it's a residential home that the people who either own the home or run the home, the caregivers are usually actually living in, or they have shifts where there's someone there 24 hours a day. The residents live there. There's these residential homes in almost every neighborhood. You don't even realize they're there. You might see a wheelchair ramp going up to the house. But other than that, it's just a regular house that is licensed. The caregivers take care of people. Generally, you either have a single bedroom, or sometimes they'll take the master bedroom and make it into a two-person room. So that saves the cost if you're sharing a room. So boarding care, there's, like I said, the caregivers there, 24 hours a day. Generally, we find that boarding care residents are usually suffering from dementias and mental impairments where they generally don't get involved in a lot of activities, whereas assisted living has lots of activities. People are still potentially a lot more involved. At boarding care level, you're generally not having that kind of activities. They take good care of you. They'll make sure all your needs are met, but generally you're just sort of sitting around watching TV or just kind of sitting there, maybe chatting a little bit. But, in certain circumstances, you're not going to participate in those activities anyway. And this is where sometimes those facilities can charge less money because they don't have to offer all those activities. I'm not saying they don't do anything. Sometimes they'll have holiday programs. Sometimes volunteers will come in and perform, things like that, but not as much as the assisted living places. And then the other type of facility is memory care. And memory care has kind of taken the place of nursing home or convalescent hospitals of the old days, where if you got dementia and you needed care, you'd go to a convalescent hospital, and that's just where you stayed. Now memory care has kind of taken over a lot of that population, which is both good and bad. Medi-Cal generally does not assist with memory care costs. And memory care is on the more expensive side because people with memory issues often have safety issues, so they need to staff better. They potentially need locks on the doors so people don't wander off and get lost down the street or get hit by a car or something. So there are more costs associated, and unfortunately Medi-Cal has not opened the doors to that type of care. So that's something, again, you're going to privately pay for. Great programs. They really have some incredible activities that, if you can afford it, are just, they're wonderful. They keep people busy doing things, cooking and crafts and all sorts of activities. But again, the cost can be prohibitive. Then there's the skilled nursing facilities, and that's, as I said, in the old days, anybody that had dementia or any kind of long-term chronic illness, that's where they went. These days, most of the skilled facilities are turning away people that just have dementia. They're saying, hey, there's memory care down the street. And it's kind of hard to say, yeah, but I can't afford it. They don't really care. They're saying that that's just not what we specialize in. So generally, when someone is really running low of funds, or if they really do have more medical needs, that's where we try and get them into the skilled nursing. And generally, the way people get into those types of facilities is they will be living at home, at a boarding care, assisted living, just somewhere else more independently. And they will have a medical event, stroke, fall, Parkinson's that's just gotten worse, any number of things that puts them into the hospital. The hospital will treat them. If they are there over 3 days, that's what it takes for Medicare to cover the initial rehabilitation in a nursing home. So from the hospital, they go to the nursing home. Medicare is covering the cost of the nursing home and the physical therapy, occupational therapy, whatever therapies they need during that period of rehab. It is a time-limited program. It's a maximum of 100 days. Usually they will try and cut that shorter. Just for your information, when they say, let's say your dad's in the nursing home, he fell, broke his hip, they're doing this rehab, and they'll suddenly say, he's ready for discharge. We're planning on discharging him tomorrow or the day after tomorrow. And you just go, oh my gosh, he's still bedridden. He can't even bear weight. What are you talking about, ready for discharge? Just so you know, those words, ready for discharge, is a code for Medicare is not going to pay anymore. It does not mean he's all better and he's ready to go home. People don't realize it's a code, and they say, oh, he's ready for discharge. I don't think so, but okay. And they try taking their loved one home, and there's all kinds of horrible things that happen. They end up back in the emergency room. So sometimes they're ready, sometimes they're not. When you get that for any loved one in a nursing home where it has not been the full 100 days and they say they're ready for discharge, look at how they're doing, look at their situation. And if you don't think that they're ready, there is an appeal process. And by law, they have to give you a written notice of discharge. This is a Medicare notice. On the back, there's a phone number that says, for an appeal, call this number. There is a legal basis for appeal. The nursing home is going to say he's not getting better. So, failure to progress. That is not the legal criteria. The legal criteria is that if you reduce the services, so in other words, he's getting physical therapy twice a day, and now he's going to go home and he's going to get it once a week, he's going to regress. In other words, he's going to lose the function that he has, or basically get worse when they're no longer doing that therapy. So the criteria is that he needs that therapy just to maintain, even if it's not making him better. You pull it away, he's going to get worse. So this is where you're going to look at the situation and say, okay, without this therapy, whatever it is, let's say it's something with his arm, they're doing range of motion every day. Nobody does that, and he doesn't do it himself. He's going to get contracted where he can't move it. He's going to lose function. He's going to get worse. He's going to need more care. These are the kinds of things that you would want to voice in the appeal when you call on the phone, that if they don't give this level of therapy, this is what's going to happen. And you need to be specific with your loved one's actual situation, whatever it is that's going on. That buys you basically at least another day. They will independently look at the records, and then they will decide If you're right, they'll approve your appeal. If you're wrong and they say, no, we think he really is ready, they'll deny the appeal. If they do deny the appeal, you have another day to make arrangements to get him out of there, or to basically ask the facility if they will keep him on as a long-term resident under private pay or Medi-Cal, and I'll get into that. But if they approve your appeal, then Medicare continues to pay, continues to get that therapy. So I just wanted you to know that part about them trying to kick people out of nursing homes. Really important to know that you do have rights there, and I've had lots of successful appeals. So it is worth doing if you really think the person is not ready and needs more of that care. There are nursing home rights. There are also rights for people in other types of facilities. Any facility that's licensed, the licensing board protects them to a certain extent. So, protects their privacy, their autonomy, protects them from what we call unsafe discharges. So certainly if you have somebody that's in a facility and you feel that they're being neglected, abused, trying to kick them out when they shouldn't, there are ways to protect yourselves from that. In the nursing home, and I believe in the assisted livings, it's generally the ombudsman. And in the facilities, they actually have to post on the wall the local ombudsman's phone number. So if there's issues going on, if you're out in the community, you often will call Adult Protective Services. In a facility, you call the ombudsman, but they basically do the same function as Adult Protective Services. They're going to go check on your loved one, make sure that bad things aren't happening. They'll do a report. They will potentially counsel the facility or cite the facility if they're doing something wrong. So that's kind of your repercussion if you feel like there's bad things going on there. But let me kind of get back to the other facilities. There are, okay, it looks like there's a question. Oh, I see. You're just giving the resource, Canner. Canner is a great resource for if you're concerned about unsafe discharges. But I just like people to know, on your own, if nothing else, call that number, start that appeal process, because you have a limited amount of time to do that. In the meantime, while you're on the phone, call Canner. They do have attorneys that can assist and guide you through that process too. The other kinds of facilities are what we call CCRCs. That's continuing care retirement communities. And that's places, if you're local to the area, like Stone Ridge Creek. There's some other ones that honestly I can't think of them right now. But essentially, those are long-term facilities where it's a whole community where you start out getting your place, whether it's an apartment or condo, or could be a full house or townhouse, and there's a buy-in for that. So you will actually pay to purchase the interest in this organization, this community, and you will have your place that you live independently. You'll pay rent every month, but part of that buy-in cost is going to go to future care expenses. So it's kind of a long-term care insurance policy that's all built into the cost of that buy-in. As your care needs progress, you can progress from independent to more assisted living, and ultimately they do have the skilled care too. When you go to a facility like that, it's obviously a big investment. A lot of times the way people get in is they sell their house, they take that chunk of money, they purchase in, then they just pay their monthly fees, and they've got a good community. These are great communities if you can afford it, and if you want to stay in, that same local, where even if your care needs go up and you have to move to another facility, you're still in the same community, so your friends are still there, which is a great thing, because nobody wants to lose their friends once you go to a facility. How often do they have the ability to come visit you? These places do give a refund of a percentage of that buy-in when you move out. that refund goes down. It starts off with higher, goes down as time goes on, because obviously you're sort of utilizing the money that was in there. But there is a minimum amount that they have to refund. And if you die, they'll refund it to your estate. So that's kind of the way that works. It is a little more complicated. And certainly if you want to tour one, they can explain to you exactly how that works. But it is more of a long-term commitment, as opposed to if you go to assisted living out, just in the community, or boarding care. Those are generally month to month. If you change your mind, you don't like it, you can move, but you don't have the same community and you don't have that big buy-in. So for a lot of people, that's the part that keeps them out. So those are the main living type of arrangements, places to receive care. There are homes. There is also the veterans homes. If you are a veteran, there are various veterans group homes throughout California. I want to say something like 10 of them. I may be wrong. And there is a website. I'm not sure if we have that in the materials. If not, I'll give it to Debbie. There's a link to the VA California homes, and their website is very helpful. Tells where each of the homes are, what kinds of care they have, that sort of thing. The most local one here is Yountville, and from what I understand, people are really happy there. But they are throughout California. So the thing with veterans homes that's nice is that they don't charge a set fee. Their fees are based on a percentage of your income. So no matter what your income is, they just take a percentage, and then the VA supplements that to whatever the full cost is. The backside of that is that as they're supplementing you through your life, they are keeping a running tally, which periodically they will send you. And I have had clients in the VA hospital that went, "Oh my gosh, I just got a bill for $300,000." And it's like, it's not really a bill. It's just a statement to keep you aware. One thing that the VA homes are very good about is telling people their rights. And one of your rights is that you can work with an attorney and you can transfer assets out of your estate. And when you die and they have that bill, if you don't have money in your estate, they won't come after it. If you just are living there, all your money's still in your name or in your own living trust, they will come after that for whatever that bill is. So it's just important, but they will tell you when you first go in, you need to talk to a lawyer. That's all they'll tell you really, is you got to talk to a lawyer to protect yourself. But these are great homes, again, all the way from independent through assisted, through skilled, great for veterans and their spouses. So those are the kinds of the main residential versus home care options. I talked a little bit about in-home support services and Medi-Cal program, but let me kind of get into the veterans, and then I'll talk about the final Medi-Cal. The veterans program, obviously the VA has lots of different benefits for veterans. If you are a career veteran, you're going to be getting your pension, which is like a retirement. That is different than the pension. They call it a pension, call it improved pension, I think, where a lot of times in the community, you've heard of it called aid and attendance. Basically, this is a separate program from a retirement pension. So if you're getting retirement pension, you can additionally get this improved pension, which is for the purpose of reimbursing you for the cost of care that you're not being able to cover from other sources. So if your medical insurance is covering it, your Medicare is covering it, even your income, if you got income coming in and that covers care, they're going to say, well, it's being paid for by your income. Where they will kick in is when all of your income is being spent on care, then this program can kick in and reimburse you up to a certain amount. And I believe I have the numbers in the handout, and I never remember numbers, so I'm not even going to try to tell you. Somewhere in the 2,000 range, 2,300 range per month. So it's a good program, but you do have to show, number one, that you need care. So there's a doctor's declaration that is required. Then that you're getting care, that somebody is providing it, whether it's at your home or in one of these facilities. If you are in assisted living or boarding care, the VA presumes that the entire cost is a care cost. So they'll look at that. If, on the other hand, you're living in an independent facility, even though it's a facility, it's considered independent living, then only the actual care costs are considered when the VA is looking at how much you're spending for care. So that's something to take into consideration. But as you're spending money for care, this is a program we want to look at as far in advance as we can. The other, just because there's some planning that potentially needs to happen. And if you will be qualified, the sooner you apply, the better, because the program is not retroactive to the time you first started having issues. It's going to be retroactive to when you applied. So we want to get started on that process. But the other criteria for eligibility for this particular program is it's only for wartime vets. And there are very specific dates of wartime, whether it's at this point World War II, still a few people, not many, Korea, Vietnam. The more recent wars have a little bit different criteria. In the older wars, you had to serve 30 days of continuous service, and it couldn't be reserves. You had to actually be called up and serving. You did not have to be overseas. You just had to be serving 30 days of active duty during that period of wartime. Now, what the criteria for, the Iraq War and that sort of thing, you actually had to serve your full term, which is a lot longer. So it's a lot more difficult for younger people to get this benefit. But for those older folks, it's a great benefit if you serve 30 days. And most people that served during that time did serve over 30 days. You did have to have, whether it's an honorable discharge or a general discharge, the primary thing is it's anything but dishonorable. If you got a dishonorable discharge, you're not eligible. I have had one client that did have a dishonorable discharge. They appealed it, got it changed, and then ultimately was allowed to get benefits. So it's not necessarily written in stone, but pretty much if it's dishonorable, you're not going to get those benefits. So anyway, this program is super helpful for paying for care at whatever level. So for veterans of wartime or their surviving spouses, definitely talk either to, so we generally send them to the VA. I'm trying to think of their names. It'll come to me. You can talk to anyone that's accredited with the VA, but just get information on it just in case it's a program that could help you. In the old days, qualifying was a lot easier than it is now. They have, in the last few years, imposed a penalty if you give away assets in order to qualify, because there is an asset limit. It's currently about $150,000, not including your house, not including a burial plot, not including a car, a few things like that. But essentially, in the old days, if you had more money, you could transfer that to your kids today and qualify tomorrow. Now there's a look back period with a penalty. So oftentimes we're saying if you're a veteran of a foreign war, before you even have care issues, not a bad idea to start talking to somebody about what kind of planning could or should I do in advance of needing that care, because that is a really helpful program if you ever do need it. And some care issues can go on for years and years and years. So even if you do some planning now and you don't qualify for a while, a few years from now, when you're still hanging in there, paying lots of money, the VA program could help you at that point. So definitely a good program. Generally, it's for, again, people that are over 65, disabled, receiving care. Obviously, you need some sort of medical or care assistance in order to qualify for this, because that's the whole program. policy is. It's to help veterans get the care they need and not run out of money before they die because they're spending it all on care. So great program. Another program with the VA for veterans is the disability program. Now, this program only is for veterans who either became disabled during service or they had some disability that got worse during service. So generally, a disability is going to show up on your discharge papers. A lot of times it'll be something minor. I see a lot of people with a 10% disability because they injured their foot and they sort of have a limp. Well, not a big deal. They can go on through life and do good things and have a full life. But if that disability, let's say that, now it's developing severe arthritis and now you're not able to walk, you can no longer bear weight because of that disability, you can actually go back to the VA, have that rating increased. So now you're not just 10% disabled, maybe you're 50% disabled. The way they do it is they rate it in 10% increments, with the least amount of disability being 10% and the most, if you're fully disabled, 100%. So somewhere along that continuum. And there's benefits based on your percentage. The first thing is you get a monthly benefit. So if you're 10%, it's really low. I want to say it's less than $200 a month. If you're 100%, it can be several $1,000s a month. So, big discrepancy. So again, if you had a disability from your service, and it has gotten worse, or it has progressed into some other disability, worth looking into, can we tie the current issues, whatever those are, with that disability and get your rating increased, get the money coming in increased, and potentially some other benefits. Once you're over 70%, it does open up some other veterans benefits for care that you wouldn't have at a lower level. So that's something we always want to look at is, it is the disability, can we increase that rating? Just a couple of quick things. That disability did not need, or that service did not need to be during wartime. The other program is wartime. This is anytime someone served and they became disabled. And again, not like totally disabled. They got some sort of injury or illness that caused some sort of permanent damage. And it did not have to be related to the actual service. So it did not have to be a bomb went off, they're disabled. For example, my father was 100% disabled veteran from the Air Force from a car accident while he was in service, totally unrelated, but he was serving at the time. He got 100% disability. So for the rest, and he really was 100% disabled, unfortunately. And so he got that, all the benefits of that, in addition to the monthly money that comes in for disability. A surviving spouse of a disabled vet can get some disability benefits for the survivor. So if your spouse had a disability, was a veteran, potentially a surviving spouse can apply for that benefit also. Sometimes the children of veterans. So again, back to my case, I have a brother who's developmentally disabled, has been disabled since birth. Because my father was 100% disabled, died from his disability. My brother, as a disabled child, now 60 years old, was entitled to benefits based on my father's service. And so he gets, I don't know, $1,200 a month, something like that for his life. So again, it's not just for the vet, it's for families, but under certain circumstances. And again, we always look at, are you a vet? Do you have any kind of disability? Has it gotten worse? And then did you serve during wartime? Are we maybe looking at the other program? If you have both, let's say, for example, you have a 10% disability, but your current issues are not related directly to that disability, we can't tie it. So, but at the same time, you're paying for care, you could qualify under the other program. They will pay you whichever program pays more. So if you're getting some under disability and you would get less under the pension program, then you're not going to get the pension. But if you're getting this disability payment and now you get more under this program, disability will go away and now you'll get the pension program instead because it's a higher amount. So that, those benefits, obviously it's monthly money coming in, does not pay directly to facilities or to your caregivers. It's reimbursement. So once you are approved, then the VA says you're approved for X number of dollars a month. It'll just come into your bank account every month. You'll continue to pay your bills. So again, if you're putting a lot out of pocket, probably not going to cover the full amount. But hopefully, if we've done good planning between your Social Security, your pension, the VA, potential other monies coming in, whether it's from family or money that you've squirreled away and is making some income, hopefully we can cover the full cost of care. Although at a certain point in our life, we are no longer in the saving mode, we are in the spend down mode. And that is a whole shift in mentality that a lot of people struggle with because they say, well, I can only afford X amount of dollars because that's what my income is. Because through your life, you don't spend more than you make. At least you're not supposed to. The younger generation doesn't have that philosophy. That's another whole discussion. But essentially, at this point, you really are probably spending some of your savings. That savings was meant for a rainy day. And when you have care issues, we're in the rainy day. So don't feel that you have to deprive yourself or your loved one of care because you can't spend down. I mean, obviously, we don't want to go destitute, and you definitely want to talk to your financial advisor, to an elder law attorney on how you can stretch those dollars, but definitely get the care that you need, even if it means you're now spending more than what you're actually taking in. Then let me just go back to Medi-Cal. So that's kind of it on VA. Again, if there's questions, well, I could stop right now and just say, are there any questions on that veterans? Because I went really broadly over that. Debbie, I see there was a few comments. Anything that you want me to answer right now?
All right, Sal, if you unmute yourself, there you go. All right. Hey, Sal.
Surprised.
Hi, Sal.
And I'm a female, so I'll say hello.
Oh,
Okay.
hi.
My question is, my husband was activated during the 1963 Cuba Missile Crisis, and he served over a year. Does that count as service for some of them?
The years between the 50s and 60s is where they have a lot of very specific dates that, like one day you're qualified, the next day you're not. I don't know that specific date, but I can find out or actually, what I will do is I will send, let me make a note. I will send Debbie a link to a list of all the dates. And if his date falls within those dates, then yes, he would qualify. If it's outside of those dates, he wouldn't. And there are certain exceptions as far as, especially Vietnam, that the dates are extended if you were actually in that place where the conflict was. So let me send that link, and I'll have Debbie post it, and that way you can check yourself. Because I'm sorry, I don't know the dates off. There's so many different dates. I just can't remember them.
Well, I understand. Thank you so much.
You're welcome.
You have lots of information. I'm sure it's hard to remember everything.
Well, exactly. Yeah, that's why you may want to watch this more than once. And again, there's lots of resources out there. So it's good to do your homework, learn about what you can do for yourselves and your families, because there's nobody else really looking out for you except yourself and those people you've set up to be able to look out for you. So you just don't want to leave things on the table. It's always hard when people come to me and say, no planning's been done. We don't know what to do. That's where generally we get stuck. Going to court, having the government involved gets even more expensive. Care is difficult. So
great. Thank you.
You're very welcome. Okay, so now what I want to talk about is Medi-Cal. Talked a little bit about the home program, but as I mentioned, boarding care facilities and assisted living facilities, and even those continuing care places where it's independent to assisted, that sort of thing. Medi-Cal does not cover those types of facilities. I think I mentioned that there is a waiver program where Medi-Cal covers certain assisted living places, but very few. And, it's always worth looking into, but that's not a program I would count on. The other thing is they close the program periodically when the waiting list is so long. And honestly, I don't even know if I think it might have opened recently, but the waiting list is generally very long. But the main Medi-Cal program that we're looking at as you age and have care issues is the long-term care program for the nursing home. And this is the program, obviously, you need to be in a nursing home. It needs to be licensed with Medi-Cal. The majority of nursing homes are, as I mentioned before, memory care is not. So sometimes people will say, oh, my mom's in a skilled nursing facility, when actually she's in a memory care facility. So there is a difference. So depending on the facility, we can find out, are they a Medi-Cal licensed facility or not? If they are, Medi-Cal rules are changing. They've been changing quite a bit over the last few years. California is by far the most liberal state in getting people eligibility for Medi-Cal. There used to be a very strict limit of how much money a person could have, $2,000, which how in the world would you ever live in California with $2,000 in the bank? But that was the limit for many, many years. A few years ago, they increased it so that a person can have $130,000. So that made it more reasonable for people that have a little bit of money, but not enough to afford this level of care for an extended period of time to qualify. Now, when you have a spouse that's at home, so one spouse is in the nursing home, the other one is at home, Medi-Cal does have provisions to protect that spouse at home so they don't go destitute paying for the spouse in the nursing home. So one of the things is they are allocated a certain amount of money that they can also have. And currently, I want to say, and don't quote me on the exact number, but it should be in the materials, something like 147,000. So whereas the spouse in the nursing home can have 130, the spouse at home can have 147. So between you, you're at 270 something $1,000, which again, it's a fair amount of money to be able to have and still qualify for that benefit. That being said, starting January of 2024, which is only 2 months away, less than 2 months. Well, 2 months. Anyway, it's that entire asset limit goes away. There will be no asset test at all. Now, the other rules with Medi-Cal will still be in play. So there are rules like if you give away money, there's going to be a penalty for giving it away. In the past, that was part of how we would qualify. If you had too much money, you'd give some money away. Now you have less money, you qualify. Now there were very strict ways of giving that money away, because if you did it wrong, you would have longer penalties, not qualify for the benefit. So there was a lot of planning that elder law attorneys did in getting those asset levels down. Again, those penalty rules are still going to be in place. So I always tell people, if we're looking at Medi-Cal coverage, nursing care coverage, don't start just giving away assets. I met with a client yesterday who said when his mom looked like she was getting in bad shape, and he's an only child, so I wasn't worried about any foul play. Good kid, but he transferred all of mom's $400,000 in brokerage accounts to his name. Well, that's nice, but now you go to apply for Medi-Cal and they're going to say, you're not eligible. You gave away way too much money. So, that's cut off her ability. That being said, if you've done that, there are things we can do. We can give it back, and replan appropriately. But just know it's not the kind of thing you should do without advice, because the Medi-Cal rules are very complicated and they aren't always logical. They're sometimes very counterintuitive. So what you think would make sense doesn't necessarily get you qualified. But that asset level will go away. The penalty problem is still going to exist. So be careful about giving away assets. But the other thing that they look at is your income. So when you go into a nursing home, they're going to look at your income and they're going to assess what they call a share of cost, which is like a co-payment. And that's based on your income and certain living things. Like if the doctor says you're going to go home within 6 months, this is a short-lived thing, they'll let you keep a little bit more of that income to potentially hold on to your house so you have a place to go when you get discharged, although it's certainly not enough to pay for rent in the Bay Area, but whatever. So basically, they're going to assign that share of cost. And what's going to happen once that's approved, you will pay the nursing home, you'll get your Social Security or whatever other income, you'll pay the nursing home that set dollar amount, and then Medi-Cal pays the whole rest of the bill. So that's kind of the way that works. If you are a married couple, there is, again, protections for that spouse at home, where a certain amount of income from the spouse in the facility will be allocated to the spouse that's at home. And there's a limit, and again, I don't know the numbers in the materials here, but it's somewhere in the $3,000 range, where let's say the wife is at home, she makes $1,000 Social Security, the husband makes $2,000 Social Security, he's in the nursing home, that $2,000 will go to the wife, his share of cost will be zero. Medi-Cal pays the full thing. On the other hand, wife made good money, she makes $5,000 a month, the husband also made good money, but because none of that money can be allocated to the wife because she's already above the limit, all of his money will go to the nursing home. So his share of cost will be whatever his income is. And then conversely, if the husband's income is low, wife's is high, wife's does not pay the facility, only the husband's. So it's whoever is in the facility, they will take your income except for the amount that can be allocated to that spouse. They'll never go to the spouse for her income or his income. So that's the general rule. There are protections that if this is the case and your share of cost is in the thousands every month, and that's not super doable over an extended period of time, especially if up to that point you've been paying for assisted living, home care, you've already been spending down your estate. That's where we can actually go to court and get a court order for spousal support. So let's say the situation where the wife is making pretty good income, so none of his income can go to her. It's all going to the nursing home, but she still can't cover the expenses. Then we get a spousal support order that says all of his income goes to her. Doesn't matter what her income is. All of his income goes to her. His share of cost goes to zero. She now has the funds to maintain the house, pay the bills, whatever else she's got to take care of, her own health issues, that sort of thing. And Medi-Cal, by law, has to abide by that court order. The other thing, in the past, we got orders to increase the asset level people could take or could keep. That's going to be a non-issue in the future, but that is something that was pretty routine. We'd go to court and say, yeah, they say that she can have, well, he could have 2,000, she could have 130, but how do you live with that in the Bay Area? So these are her needs. We would explain to the judge, and the judge would say, yeah, she needs more money than that. We're going to allow her to keep $500,000 or whatever it is in order to take care of her needs. And again, then Medi-Cal has to honor that. And even though they were over the asset limit, they would qualify. As I said, that rule is going away, but the income issue is going to be at play. The other issue that I see going forward, that this is just me looking at the situation, more and more facilities have been having less and less long-term beds, turning more of their beds into short-term rehabilitation beds, because that's what Medicare pays, and Medicare pays them well for it. So there's less beds available just in the area. The cost of running those places, unfortunately, is high because of all the regulations. So a lot of people are saying, I don't want to own a nursing home. So there's not a lot of incentive for people to open homes. So we have a very limited supply of nursing homes, along with a dwindling bed count. And I think once they eliminate that asset limit and everybody qualifies, they may reduce what Medi-Cal actually pays. It's like any benefit. You got this benefit, it pays something, but if everybody's got that benefit at a certain point, it's not covering anything. So that again is my concern, that you may get the benefit, but what's it actually going to benefit? And we won't know until the time comes. And hopefully we will have ways of working around that in order to protect people going forward, because we've got a whole aging population that's going to need these benefits. So I do see we're running late. I think I've talked about the bulk of things that we wanted to talk about. I think I mentioned the long-term care insurance. Elder abuse, like I say, not something that I deal with, but there are resources that we're providing to you that can give you more information on that. And certainly I'm available. You have my contact information. As I said, I'm going to send Debbie a couple of links for you. And I do highly recommend that you attend that Medicare program and all of the programs that Debbie's putting together. They really are good programs, a lot of good information. And I hope today was good information for all of you and helpful.